Oh, it's not giving, 1 moment, please. It's not giving me permission. Well, it's not giving me permission to go live. I don't know why. 1 moment. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you, Ms. Silverman. At this time, we'll go on and call the docket for this morning. But before I do that, I want to thank the attorneys for agreeing to appear through Zoom to discuss this case. Without the Zoom, we'd have had to postpone it in order to make arrangements to come down and travel, and we kind of hesitate doing that delay. So again, appreciate you agreeing to do the Zoom submission. And I don't think none of you look familiar. Now I'm getting older. You may have argued last week and I forgot. But just as a matter of background, if you haven't argued before this court, we tend to ask a lot of questions. Some people say it's a hot panel. I don't know. We just like it to ask questions. Do not read more into the questions than them just being questions. We play devil's advocate at times. So we would appreciate just a short answer, a direct answer. If you need to expound on it, that's great, but a direct answer is very important. Over time, we can tell when people like to do a little soft shoe. Not that we don't mind soft shoes, you know, they're great on movie screens, but sometimes they're not great during a hearing. But a direct answer would be very much appreciated. 20 minutes per side. I understand the appellants are splitting their time, or the appellant attorneys are splitting their time. Is that correct?
It is.
Are you going to have that feedback, you think?
Zoom is not muted.
Oh, that's not.
What's that?
I think we should be good now, Judge.
Okay. And are you going to just split your time 10-10 or what?
Judge, we're both prepared to argue our respective points for 10 minutes each, but we were going to take a little bit of guidance on that and be flexible based on the questions that we received. So I'll be going first, and we're going to be flexible based on how many questions you have for me and take a little guidance from that.
Very good. And we will let you keep your own time. Of course, you'll see the timer up there. You do have 20 minutes. So we're not going to stop and say, hey, 10 minutes is up, change or anything like that. So you'll have to police your own time if you don't mind. Okay. With that, we'll go on and call the docket. So case we have this morning, Wednesday, August 2nd, 2023 for the 7th Court of Appeals is styled 07-22-00204-CR Barry Allen Boes II versus the state of Texas. And we have counsel here representing the appellant is, well, I'll have you announce yourselves. How's that?
Yes, sir.
For the appellant?
My name is Angelica Cogliano, and my co-counsel is William Hines.
Very good. And given that you're here, I assume that you're ready to go.
Yes, sir. We are ready.
Okay. Okay. And for the state?
Daniel Sakita for the state. State's ready.
Very good. Thank you. And with that, Ms. Cogliano, you got the floor.
Thank you, Justice. I'll be starting and covering mainly the issue of First Amendment and free speech, which kind of combines the issue of definition of communication and sufficiency. And then Mr. Hines will be addressing the issue of the juror misconduct and Rule of Evidence 608. And I'd like to start by acknowledging that the issues in this case really concern an important line that gets drawn between protecting victims of domestic violence and of assault, and also protecting our First Amendment rights to free speech. And of course, the law moves much more slowly than technology and the internet. And so unfortunately, we don't have a lot of precedent to rely on these particular issues out of Texas just yet. The majority of the case law on this issue is specifically talking about true threats or threatening speech. on the internet or on social media. But we don't yet have a case out of Texas, and most states do not have a case that simply addresses posting on social media, not in a direct communication or a direct message, and not a threatening contact or a threatening message. But I found it helpful to look at the other states that have had these opinions. And also I want to call the court's attention to a law review article called Protective Orders, Social Media, and Free Speech that came out of the Yale Law Review in 2019. And
Is that, counsel, is that cited in your brief?
Judge, it's not, and I'm happy to provide that citation to the court
Please
after
do.
the argument. And this law review article, the author comes to the ultimate conclusion that states should, in certain situations, be able to prohibit certain individuals from posting certain things on social media about other certain individuals. And I agree with that author's ultimate opinion. Personally, as a survivor of assault, I could see situations where that would be prudent for the state. But I also agree with the author's ultimate conclusion that if that's going to be done, it has to be done properly, intentionally, and in compliance with the First Amendment. And in his variety of solutions and how to do it properly, he only cites one that would be improper. And that's an attempt to redefine contact or communication to include any reference to a person on social media. And what he means by that is, instead of creating a new law to make sure that it complies with the First Amendment and to make sure that it's constitutional, you can't just decide that an existing law that is directed at a different kind of communication suddenly applies also to simply posting into a public forum something about the protected individual. And there's three
Counsel,
reasons.
did the Supreme Court in Counterman against Colorado just decide this issue June the 27th of this year?
Judge, so in Counterman versus Colorado, the Supreme Court did address the importance of intent when you are limiting free speech in a similar context. Of course, in that case, it was a true threat case, which has a little bit of a different analysis than a simple protective order case. But they highlighted how important it is to make sure that when you are criminalizing or prohibiting speech in the social media context, in the internet context, that you do so in a way that requires the individual who is being suspected of violating that law that they knew and intended to engage in the conduct that's being criminalized. And it lends itself to the reasons that I was citing about why you can't just reinterpret protective order law to include a statement made to a public forum that's not directly to the protected individual and suddenly use that kind of a law to criminalize that conduct.
Now, counsel, this case is a little different though, because of the tagging aspect on Facebook, right? I mean, it essentially was directed at the person who was supposed to be protected by the protective order, right?
Judge, I think that would depend on if you determine that the activity of tagging is a direct communication. And I would submit to you that it is not. First of all, I don't believe that there was sufficient evidence presented at this trial to determine that the defendant, Mr. Boes, intentionally and directly communicated with the protected individual by tagging her.
Real quick, tagging, explain that to me.
So Judge, tagging, and I want to be careful about this because I don't want to add facts into the record that aren't, but from the record, what we've learned is that tagging is a mechanism on Facebook that can, but does not always, notify an individual that you are posting about them. But there are settings on Facebook, one, that determine whether or not something is automatically tagged, and two, whether or not the individual that is tagged is receiving the notification that that occurred. But what
does a Facebook user have the ability when they're posting something to select tag or not tag?
So what the evidence came out, what's in our record, Judge, is that in some circumstances, there is an option for the person to choose whether they're tagging or not tagging. But when that option does occur, it does not tell the person whether or not the individual that's being tagged will be notified. So the person,
if I create a Facebook page, my first time ever, And my first comment message is a statement, and I use your name. Will Facebook find you and tell you I used your name?
Judge, I believe that would depend on my settings. And I think it would also depend on if we were friends on Facebook, how much interaction you and I have on Facebook.
No,
and how-
I mean, I never friended you or anything. Would it just
Correct.
send you something automatically?
Not always. And so that's what we've learned from some of the testimony that came out at trial, and otherwise is that, and especially also from some of the testimony that was provided in the motion for new trial.
So somehow I'm going to have to do something in order to get what I say about you sent to you.
Correct. And when you do engage in that conduct, it does not always get sent to you. And importantly, Judge, just the action in and of itself does not mean that the person who did the tagging knew that in doing so, that would notify or be a direct communication to the individual that was tagged. So
I have a two-part question related off of that answer.
Yes, sir.
First part, is it your argument or your position that the person who posts, they have to intentionally do something to tag this person versus Facebook doing it automatically? The second part of that question is, does it have to be a communication then for the person to receive the notification? Do you get what I'm saying?
I do.
Okay.
So to answer your first question, Justice, my position is that the evidence in the record indicates that sometimes the person does have to intentionally do something in order for the individual that's tagged to get a notification, but it did not establish that that is always the case. And to answer your second question, Judge, no, in order to commit the offense of violation of a protective order, the communication does not have to reach the protected individual. But I think what we learned from Counterman versus Colorado is the importance of the subjective mens rea requirement in offenses that criminalize communication and conduct in a public forum, meaning that the person who is the defendant in this case, the person who's not allowed to contact the protected individual, has to know that what they're doing constitutes the communication and constitutes conduct that would violate the protective order. And in this case, our record does not establish beyond a reasonable doubt, and we believe that no reasonable juror could find that it was proven beyond a reasonable doubt, that the defendant had the subjective intent, which in our case is even higher than that which the Supreme Court is now requiring for true threat cases. In true threat cases, the Supreme Court in Colorado, Counterman versus Colorado, requires at minimum a recklessness mens rea. But in the state of Texas, to have a violation of a protective order, which is a different kind of speech, it needs to be an intentional or knowing communication. And what the evidence established at trial through the interview that Mr. Boes had with the police department was that he was aware that his post may come across the protected person's Facebook on her wall, but not that he knew that she would get a notification or that his intent at all, his subjective intent, was to intentionally or knowingly communicate with Dr. Sheila Boes. And that part is very important, Judge, that his subjective intent in posting on social media did not establish, one, that he knew tagging would notify her at all, and it doesn't establish, two, that his intent is that it would. And many courts across the United States that have addressed this, including the High Court in Georgia, in Florida, in New Mexico, and in Minnesota, established that communication about a person who could reasonably be expected to discover it is not the same as contact, which can be prohibited by a protective order.
Very quickly, I'm looking at the state's brief, and on page 1, under their fact statements, they make the statement that Appellant admitted that he had made these communications when asked by the detective, and further agreed that he expected the communications to show up on a Facebook timeline. If he expected that it would show up, is that enough?
No, Judge. And so if you go to the record that the state's brief is referencing, what the detective talks about with Mr. Boes is whether or not he knew it was possible that she would see it. And I think that's exactly the same premise that I was just discussing from these other high courts and other
There's a
states.
difference between possible and expected, isn't there?
Yes, Judge, exactly.
Are you
So
saying that the detective didn't say he expected it would show up?
correct. So when you look at the actual transcript from this trial, what the detective said was that he asked Mr. Boes if he knew that or intended for Dr. Sheila Boes to receive and know about that post. He said that he knew that when he's tagged in things, sometimes it did come up on his newsfeed. And when that term expected is being used, it's not that that's his intent, that's his goal. It's just that he did know that it was possible. And I would compare that to somebody making a billboard somewhere or writing a blog post or a tell-all novel where they're or talking just with friends. If I'm talking with friends and I know it's possible that my friend might then go tell somebody else what I said about them, that's not the same, Judge, as proving beyond a reasonable doubt that I intentionally or knowingly had the subjective intent for that person to hear what I'm talking about. It just means that
one of the differences we've got, though, I mean, it's possible that it would happen, but he did it anyway, is that we've got to give deference to the judge's or the fact finder's findings on whether a reasonable person would believe that that intent could be inferred from that. Are you saying that the mere possibility that somebody did it knowing it was possible is not sufficient to satisfy that burden?
Yes, Judge. And I think that one thing we have that's very helpful for us in acknowledging that is the extensive note that the jurors sent out to the court during their deliberations, which was 3 pages and very clearly asking over and over again, if he knew it might show up on her wall, is that good enough? They asked that several times in the record, and that note is included in the record in this case because that was their concern. The reason they convicted Mr. Boes is exactly the concern that we have about the First Amendment and exactly the concern we have about sufficiency here, which is that they convicted him because they knew that he knew it was possible that she would see it. And that does not meet the burden that the state needs to meet in order to overcome First Amendment protections and in order to overcome the need for proof beyond a reasonable doubt and that sufficiency requirement.
He's speaking about the jury. Don't we have another jury problem here?
Yes, Judge. And so at this point, unless you have any more questions for me, I'd like to pass the baton over to Mr. Hines to address the jury problem.
Or should I say alleged jury problem?
Good morning. May it please the court. The issue I wanted to address for the court is one that Chief Justice Quinn just alluded to, was the jury misconduct. And I wanted to discuss the no impeachment rule as codified in Texas Rules of Evidence 606B and its constitutional limits. There are many good reasons for the no impeachment rule, but there is really grave danger, I think, in its inflexibility. A danger such as a jury could find somebody guilty solely because of their race, come out and have a press conference on the steps of the courthouse, and Rule 606B says there's nothing you can do about it because you can't take their statements, testimony, or an affidavit regarding their deliberations. And thankfully, in 2017, Pena Rodriguez versus Colorado has said that we are not going to allow that. There are certain biases, prejudices that require the Sixth Amendment requires 606B to give way. And I believe that the rationale in that court and all the predecessor cases demand an exception for the Fifth Amendment in this case, because I think it's without question the jurors submitted 2 different statements that indicate clear bias. I know that Justice Quinn authored an opinion in, I want to say it was Santa Cruz v. State, where the same issue arose, but the court found that the statement of bias was not clear enough. The statement here is very clear. And the Supreme Court of the United States has struggled for 170 years with this no impeachment rule, and almost always came down on the side of a strict interpretation of 606B. But they also have clearly said for many, many years that there is very large danger and that there will be cases in which the Sixth Amendment and the right to an impartial and fair trial, it trumps 606B, and 606B has to give way. For example, as early as 1852 in U.S. v. Reed, the court said it would perhaps hardly be safe to lay down any general rule on verdict impeachment because cases might arise in which it would be impossible to refuse juror testimony without violating the plainest principles of justice. And Justice in Tanner v. U.S., which is the famous case which talked about safeguards, said
I think
is there any sure is there any evidence in the record that it was more than just this single juror? I mean, she didn't share this thought.
That's correct. It's a single juror, but I would suggest to the court that that's enough. If one person says, I voted, and the key, I think, if you look at that record and what the statement says, the inquiry where that statement came up said, what is the determining factor or key piece of evidence that caused you to vote guilty? And she said point blank and succinctly, because he didn't testify. Right. And so we have two theories of admissibility. One is that Pena versus Rodriguez has created an exception, right? That there is a constitutional exception where the case is so egregious that it impugns the right to a fair and impartial trial. And I think they found race was one of those, and certainly Fifth Amendment is equally important.
To find in favor of the appellant here, would we have to hold that essentially law and order was an outside influence? I mean, if we were,
I don't think so, Judge. That's a codified exception. Outside influence is one of the statutory exceptions. Pena Rodriguez says that beyond that, the Constitution is the limit. And you would have to find that under Pena Rodriguez, that the Fifth Amendment is such an egregious violation that it creates a constitutional exception. There is a second way that I'd suggest for the court.
Let me ask you on the first argument. Did you argue Pena Rodriguez and its application in your brief?
We did not, Judge. As the court is aware, I did not write that, but in preparing for this, it became very clear that that was important. We did argue jury misconduct, and I think there's the threshold issue. Can you have evidence of it? Because if you say 606, a stringent application of 606B, you say, okay, well, yes, we know that happened, but it's not cognizable because of 606B. There are two separate ways. Because the juror Rogers gave two statements. One was the statement in response to the question. The other was a response to our investigator. Right, so the court could find either constitutional exception under Pena Rodriguez, or you could say the second exception is not a statement regarding deliberations; it is a statement of bias.
Right, but let me ask it this way: with regard to jury misconduct on failing to answer the question with regard to the judge, there's nothing in the record that indicates she said anything, right?
That's correct, but there are many cases where, and especially the Texas case of Von January, and also
I'm familiar with the case. I was really intending to ask you the next question, which is, it didn't look to me that trial counsel specifically asked a question to the panel even about how they would vote. So I don't know that she was under an obligation to answer there. But with regard to trial counsel, is there anybody here, if you receive that instruction, that would hold it against this defendant if he doesn't testify? That seems to be the only place in the record where Rogers might have had some sort of obligation to answer any question. Will you show me if I'm wrong on where you disagree with me on that?
Well, I think that the Justice, you're accurate on that, but I believe the court also in the court's voir dire, they addressed that issue as well. And so I think there were two separate places. And certainly what happens in many cases of alleged juror misconduct is that another juror will give evidence of it later, and then the juror will go, okay, because there's court instructions. trials in Texas start the same way and end the same way every time. And so there, I don't think that it's reasonable to say that she didn't know that bias should have been disclosed. And
I know that it looks like we've run out of time. Let me ask if Justice Doss or Justice Yarborough have any further questions at this point.
No.
I don't have any.
Okay. Of course, you have the appellants have a 5-minute rebuttal, and Mr. Hines, you can fight with Ms. Cogliano to see who's going to take that time. Okay.
yes, sir.
Okay. Thank you. Mrs. Cutter.
May it please the court, counsel. The crux of this case is actually slightly different than the Counterman case that we discussed a little bit in appellant's argument, and it's distinct in a very important way. The allegations in this case are not regarding violating just a statute that exists, absent any notice necessarily to the defendant or the speaker in this case. In this case, the speaker, Barry Allen Boes, was the target of a protective order, which specifically told him to, quote, do not go near or attempt any communication directly or indirectly with the following person, people, or the following locations. The only person listed is the victim, Sheila Boes. That is a very specific warning. It's a very direct warning, and it's something that is also limited in time, which the court, the Court of Criminal Appeals has noted are some of the requirements we want in these sorts of absolute bans on any communication. Counterman deals with a case where the individual was stalking the target over an extended period of time on Facebook. And part of that stalking included hundreds and hundreds of messages sent over Facebook. And the mens rea in that case was targeting not that they knew or didn't know if the communication was happening, but it was a subjective recklessness that the Supreme Court wants to apply as to the threatening nature of those communications. In this case, there's no reason under the statute, as it's applied in this case, to have to get anywhere near the true threats doctrine. The protective order could have been written in a way which prevented threatening contact, but in this case, it was not. It was written in a specific way, which is allowed by the code, to not have any actual or attempted communication, direct or indirect, with a specific individual for a limited amount of time as a result of an assault case.
So is it actual or attempted? If I send a message and there's no evidence that it's received, do I still violate the protective order?
That is how it is written, Judge. And I think that's the correct interpretation for protective orders. There's no actual requirement that they receive the communication. So, for example, if a letter was mailed but never actually opened, it would still count as a communication.
And what's the mens rea?
The mens rea is just, I believe there's no mens rea as to the content of the speech. I believe the mens rea is just that he knew that he was communicating or intended to communicate with the target in this case. And that's exactly what he testified, well, that what he talked about with Detective Taro. As Chief Justice Quinn noted, there's a section in part of the examination where Detective Taro had investigated the case, was talking with the defendant, and when questioning, the defendant said, what I believed was that every post showed up on her page. And he also said at a different point, I thought it would show up on her timeline. I believe those statements give us sufficient mens rea for the defendant's knowledge in this case, that he was attempting to communicate and meant to communicate these indications to Sheila Boes. Additionally, the victim in this case, the target, also testified to the jury that she did in fact receive those notifications from being tagged. And as part of that is also, as the court noted a little bit before, that the tagging is a deliberate act. If you simply went to Facebook and typed in someone's name, the testimony on the record, again for Detective Tara, is that you would need to have a deliberate act in addition to just typing in someone's name. The state agrees
what
that
if he just posted something on Facebook, nothing to do with Dr. Boes or something innocuous? This is what I ate for breakfast, and he took a picture of it. And he thought, well, maybe she'll see it on her timeline, but it wasn't directed at her. Is that still violating the protective order?
I don't think it would, Your Honor, in this case, because of the way, well, It might violate the protective order. I know in this case, the way it was charged was specifically the allegations of tagging was the communication in this case, as per the indictment. If he thought that if there was a situation where we had some indication he meant to communicate with her, possibly we would need more facts than were in this record, though, I believe, to establish that. If he has 1,000 friends on Facebook and there's a possibility that she sees it, I don't think that would constitute any sort of communication with her. But the extra step,
is that because in your view it's not directed towards her?
Yes, Your Honor. The tagging directs it specifically towards her. He's aware, and from the record, that it may give her notifications. He's aware that he expected it to show up on her page. And in addition, it's an additional deliberate step. If he had, for example, posted that picture of his breakfast and typed, "I'm thinking of my ex Sheila," but hadn't tagged her, I don't think that would qualify as any sort of direction towards her necessarily. That'd be similar to posting something in a public forum, say a newspaper, without any direction towards an individual.
So there's the tagging. It's the tagging that is the extra step here.
Yes, Your Honor. And because of the deliberate nature of that, I believe that it should not have any issues with the First Amendment here. And I think that the analysis in Counterman is very instructive if this was a true threats case. But because it's not a true threats case, the subjective mens rea.
Well, counsel, let's go back to Judge Yarborough's question. If he assume he knew that she was tagged and would get his comments, even if he was talking about his breakfast, why wouldn't that be a communication?
Because I misspoke. I'm sorry. If tagged, yes, that would be a communication. I thought the question was, that if she was not tagged in that circumstance, but that he was aware that it might show up in her feed. If tagged, I believe that would establish communication. Does that answer your question, Chief Judge?
Yeah.
Okay. My misspeak. And I believe that those differences with Counterman are instructive in this case. Counterman discusses several other mens rea standards that apply in First Amendment cases. They're different depending on exactly what's being spoken. Of course, there's a reckless disregard for the truth. If it's a public figure, there's an objective standard for fighting words. I think this is somewhat closer to obscenity in that there's not a standard of knowing what the obscenity is, just knowing that you have something and that it could be obscene essentially. I think in this case, because of the direct notice to the defendant through the protective order of exactly who he was not supposed to communicate with and how long, there's no chilling effect here because it's not going to continue beyond a certain length of time. This has very little impact on any sort of public discourse regarding anything political because it's just between these two individuals. And I believe there's no problem as this statute is applied to the defendant in this case.
I'm going to move the line just a little bit. What if he did post about his wife, but didn't tag her?
I don't know if that, I would say no, Judge. If I would say absent the deliberate act to send a communication or in a deliberate act that he thought would increase the ability of her to see that, which is the tagging, I don't think that would communicate anything to her directly. Absent some strange fact pattern where they're the only two friends with each other on Facebook and he only sees her messages, he only sees his posts. I don't see that necessarily qualifying in that case. That's not the facts we have here, though.
Is there any responsibility on the part of the recipient of the communication to block the communication? Or is it just one way from the sender, so to speak?
In this case, there is only the responsibility of the speaker in this case not to send anything. The law tends to not put burdens on the victims in this case, especially because she's already the victim of a separate assault, which was the generating instance for this happening. Typically, we don't like to tell the victims how they must behave or what they must do to prevent something from happening like this. And so, to be clear, I believe Justice Doss mentioned earlier that there is a little bit of difference in this case. There are two different exhibits in the record from Facebook, one saying that tagging will affirmatively notify the target of the tagging, And there's another exhibit from defense from a different part of the terms of service, which indicate that it may notify the individual that was being tagged. In this case, given the disparity in that, I think resolving that in favor of the fact finder in this case, which would be for guilt, I think that's the correct outcome given the case law on these sorts of issues. Additionally, the jury had more than enough facts than just that to back them up, including the statements that the defendant made to Detective Taro regarding his intent and his understanding of how tagging worked, and the victim's testimony that she was in fact notified of the tagging in this case.
Yeah, and refresh my memory, if I can't recall if the record or the briefs mentioned how many communications were actually received by the victim.
It's at least 2, Your Honor. I believe it might have been 3 that were attempted. Let me double check. I believe it was at least 2, Judge. And that's for the nature, that's for the felony charge. It needs to be at least twice during that period.
Thank you.
Addressing a little bit, unless there's any further questions on the First Amendment issue or the tagging issue. All right, moving to the juror issue in this case. Appellant in their brief cites 3 cases, Santa Cruz, Salazar, and Bon January, for issues where a juror could have been excluded because of their bias that was not revealed in voir dire. I understand counsel that's arguing today is not the same counsel that actually physically wrote this brief. But just to address those specifically, each one of those is easily distinguishable from the instant case, because those regard specific abilities and knowledge that those jurors had from their biographical history. They knew the defendant or they knew the victim. In Santa Cruz, they knew the defendant. In Salazar, the juror was the witness to a different offense, but similar in that the ethnicities of the defendant and the victim were the same. It was also a sexual offense, and that could have had an impact on his ability to be fair in the case. That said,
why are those distinguishing factors relevant for, why should that guide our analysis?
My argument would be, Your Honor, that those distinguishing factors should mean that these cases should not apply in this case. The difference in those cases those are just aspects of those individual jurors that would make them biased in this specific case. In this case, the only testimony we have is from Juror Rogers in that questionnaire in the affidavit saying why she eventually made her decision. She never says that's what she would always do. She never says that's just her makeup. That's what she deeply believes. She basically responded to a questionnaire with a statement that's like, well, I didn't like that he didn't testify, and that's why I ruled guilty.
Right, but let me direct you back to where the judge is asking the entire panel the following question. The court says, if the defendant chooses not to testify, you will receive an instruction that you cannot consider that testimony, that failure to testify for any purpose whatsoever. Then the judge says a number of things and then says at the very end, is there anybody here, if you receive that instruction, that would hold it against this defendant if he doesn't testify? Anyone? Then there was silence. And the judge says, okay, I don't see any hands being raised, so I'll hold you to that. Now, I agree that there are a number of cases since the 60s that say the questions to an entire panel are usually a poor way of determining whether or not somebody's committed, misconduct by not answering a question or not. But the judge appears to ask a pretty specific question about if you receive the instruction to not consider this, you're going to hold it against him. And that's the very thing she did, it seems like.
It may have been the thing that she did, Your Honor. It's basically our contention is that there's nothing in the record that establishes that was her state of mind at the time that she was asked that question by the judge. It is possible that she understood that to be the law, thought she could follow it, thought it was not an issue at the time, and eventually became an issue later.
How does one determine, for purposes of us writing an opinion about this, how could one determine what a juror's state of mind is at the time if the juror doesn't ever answer the question?
I think that's it depending on the affidavit they write or what they put into the record, possibly, but I believe this is the kind of fishing expeditions that Rule 606 is meant to prevent us from getting into. Jurors will occasionally say things after the fact that could create these sorts of questions on numerous cases. And it's very difficult to read into a juror's mind. They might be imprecise with language. There's a reason that we often call jurors up during selection to narrow down exactly what their issue may be with the case or with a rule that the court has, because jurors are not legal entities. They're typically lay individuals. They have poor understandings of the law. They have poor understandings of exactly what these legal terms mean. And without being able to question them specifically on it, it's going to be complicated. And that's exactly why I believe Rule 606 exists, is to prevent us from diving into these deliberations and these states of mind of the jurors, because it's going to be...
Doesn't the same principle that was articulated in Santa Cruz kind of apply? I mean, I may be mixing it up, but I thought Santa Cruz was the one where the court asked if anybody knew the defendant. There was silence, and then later we find out that one of the jurors knew the defendant. Here, the court says, hey, is everybody going to be okay if they don't take the stand? There's silence, and then later we find out, oh yeah, she had a problem with that.
They're related, Judge. I think the fact that in Santa Cruz, because of the nature of the relationship, that was the defining fact. The fact that they did know the defendant, that's what made that juror ineligible to serve. In this case, again, I don't know that there's any indication of what the juror thought at the time during the selection. They may have had a problem later there. There's just no way to know from the record that we currently have. And there's nothing in the juror's biographical history that's in the record that would indicate that they always believed that, merely that they've seen some, law and order. Does that answer your question? I see some.
Yes.
No.
Remind me again how long the jury trial was?
I believe it was a couple days. Mr. Hines might be able to answer that more, because I know it was one day. Right. He was actually trial counsel, so he would have a better awareness of that than I did. And so then the jury...
It was a one-day trial, and it's the state's position that this juror's position on defendants who take the stand might change over the course of that one-day trial.
It'd be our position that we don't have any evidence in the testimony in the record, Your Honor, of what their state of mind was during the voir dire's part. And absent that, I don't think that we can say that the trial court abused their discretion in denying the motion for new trial. Would
it matter if she was being deceitful? Like if there was evidence in the record that she withheld this opinion and then we later discovered it?
Possibly. It might affect the analysis a little bit, Judge. I don't think that there's, as Appellant kind of conceded, there is no case law directly on point for this circumstance. I think following the letter of the law under 606 leads us to say that it legally doesn't matter. It might matter in practice how we look at it. It might make a better case. I don't think that under the law in this case, it actually makes any difference, because this evidence just falls into 606, generally speaking.
What do you say with regard to Mr. Hines' constitutional argument?
So I have not read, I have to defer the briefing on Pena Rodriguez versus Colorado. I did not read that case. It wasn't provided in the briefing working up to this argument. I understand because it's a change in counsel that may be different. I think it's distinguishable. The difference in, again, these sorts of cases, until we have some sort of clear guidance from the Court of Criminal Appeals on exactly how we want to parse these situations out, I think it's going to be very difficult to just create new rules every time something happens here. 606 could have been written in a way that provided for either specific issues like Fifth Amendment and Sixth Amendment arguments to be brought up in these sorts of circumstances.
You're not suggesting 606 trumps the Constitution if there's a valid constitutional argument, correct?
No, I'm not, Your Honor. That is correct. That is not my argument. My argument would simply be that 606 provides a way for some finality with verdicts without allowing fishing expeditions into every single jury verdict. And part of the analysis that it gets to is that it very strictly limits the investigation into jury deliberations. It could have opened it up a little bit farther to say if there's an indication of a violation of an amendment, a constitutional right or something, we'll have a broader view. But absent clear guidance from the Court of Criminal Appeals on that, and absent a specific rule that I think that would be breaking new ground for this court.
Was it just quickly, if was the constitutional argument raised at trial?
I don't believe so. I'll leave that to appellant to address on rebuttal, but I don't believe it was directly, Your Honor.
If it wasn't raised at trial and it's not actually mentioned in the brief, is that something we can even consider at this point?
I would argue no, Your Honor. Any further questions? I see I'm about to run out of time.
Judge Doss, Judge Yarborough?
No.
No.
Thank
Thank you,
counsel.
Justices.
Mhm. Who's going to do the rebuttal?
If it pleases the court, I will address first the statement that there's no indication in the record about what Juror Rogers' state of mind was at the time of jury selection. And I direct the court's attention to Exhibit C of appellant's brief, where there's a transcript of the interview with Juror Rogers. And she says fairly clearly, because television, a person's guilty when they don't testify. I think it is a reasonable inference, certainly, that the court could make that belief was strong and predated the jury. The idea that she somehow saw an episode of Law and Order during a break in the trial is probably not a reasonable inference.
It's amazing, counsel, how many people or that people see something on TV or read on the internet and they say, well, it's got to be true.
No, it is crazy to see how voir dire has changed over the years, where many prosecutors will address law and order in their jury selection. And so I think the court clearly could say that based on the transcript, that was a bias that should have been revealed, and therefore that there was jury misconduct. But we still have to get back to the threshold question of, can you
Wouldn't that be an outside influence?
I mean, I think there have been cases that say TV shows, unless they're being watched in the jury room or that it occurred that night and we don't have evidence of that, I don't think that applies in this case. I hate to say that, but that's the way I feel. And I think that's what the law is. But I think that the court could find, because there are two statements, that the second statement is a statement of bias. It's not a statement of deliberation, therefore 606B doesn't apply. But I feel like that Pena Rodriguez versus Colorado, even though not cited, is certainly an important enough constitutional basis, and that we did raise juror misconduct.
Is watching a TV show the same type of bias as relying on racial prejudice? Or
well, Judge, I would say it is, because the Fifth Amendment is special. It's different because it implicates so many rights. For example, if we allow these kind of violations to go unchecked, it erodes the other Tanner safeguards that were in place in that United States Supreme Court case. And for example, if we say we're going to allow that to stand and not address it because 606B, it erodes the beyond reasonable doubt standard, because the prosecutor could get all the way to preponderance and then just consider the not testimony as the rest of the way.
But is it race, a suspect classification that's been adjudicated many years? That has
it is, Judge.
But it has a special place in our jurisprudence, and I understand what the right against self-incrimination does too. But given the different attention applied to suspect classifications, can we say carry that over to constitutional rights?
I think you can, and the Supreme Court has said for 170 years they have warned about exactly this, that there will be cases so egregious, like I voted because he didn't testify. That is so egregious because it implicates many of the other constitutional safeguards that we have, which is the basis for 606B, that they say in Pena, they say, because this implicates unique historical, constitutional, institutional concerns is why we're going to say Sixth Amendment says 606B has to give way. And the Fifth Amendment, I would say, is, if not equally important, just marginally less important, because without the Fifth Amendment, your right to a fair and impartial trial, as required not only by the Constitution, but by Texas Rule of Appellate Procedure 21.3.
But can you have a Pena Rodriguez type violation with just one juror keeping that thoughts to herself? I mean, the way I look at Pena Rodriguez, they didn't want racism spreading amongst the jury and then making the decision on that. Here we have one juror.
I would say that the principles are equally important. And the fact that she didn't communicate it didn't mean that that wasn't the deciding factor in her vote to convict, right? Just like a deciding factor of race, we want them to focus on the evidence. And so I would say, because a question that has arisen, well, where does it stop, right? And the Supreme Court has said over and over and over that it stops where it implicates the right to a fair and impartial trial. And I think a single juror that does that is not acceptable.
Looks like time expired, counsel. Are there any other questions for Judge Doss, Judge Yarborough?
No.
Thank you. We appreciate your agreement again to present your arguments through Zoom. The case is submitted. Our opinion will be forthcoming, and you are excused to go. Have a great day, and hopefully your air conditioners are working well throughout Texas, especially where you guys are. So, and take care.
Thank you, Judge.
Thank you.
Thank you, Honor.
Thank y'all.